Patent Insider. Basically, if you've been watching us for a while, this is still, we're talking about the third step of the 4 fundamental steps of the patent process. We talked about the other 2. If you want to go back, you can look at some of our previous videos, but basically, we're talking about the 4 fundamental steps. Today, we're talking about the third step, which is the non-provisional utility application, and we're going to step B, or like I said, the second part of this. I guess I'll break this down into 3 parts. The first part being the initial filing. Right now, today, we're talking about the second part, which is really the bulk of what matters with the patent process. This is where it gets down to brass tacks, or you get down to business with the patent office. The second part is the entire examination and patent prosecution process. What does that mean? So we talked about this, I guess, in the first video about when you first have your idea. Usually creativity is driven by solving a problem. There's something out there that's bugging you. You're like, man, I need to figure out a way to solve this. So you solve that problem, but guess what? That's not just your problem. Somebody else has that same problem. And so somebody else may have tried to solve that problem the same way, or maybe slightly different, but enough that it would make your idea not a new idea. So in the beginning, we try to put you in the best situation by doing a patentability search and assessment on the front end. But that's a snapshot in time. The patent office, the government, has unlimited resources to search. I mean, when I was examiner, it was nothing for me to perform over 100 searches on one application. Over 100 searches. So, and that's not just at one time. That would be at the beginning when I first got the application. I'd perform a number of searches. I might perform up to 100 searches in that first time. Then after I send my opinion, which is called an office action, I send that out to the applicant. When they send back a response, which is this is the prosecution process. It's basically like an argument, a polite argument on paper that goes back and forth with some phone calls. But we have to basically come to an agreement on your invention, whether it's 3 things. Whether is your invention novel, meaning is it new, or has somebody thought of it before? Is it non-obvious? Basically, is it just, did you just pick up 2 things that are already being used in our public information and put them together? That would be obvious. So you say, oh, I have a coffee cup with a lid. Now I'm going to put motor oil in it. Now it's a motor oil cup. It looks just like a Starbucks cup. That's obvious. It's a Starbucks cup is a container holding hot liquid. If oil is hot, it can hold hot oil. Why not? So that's I guess a quick example of what could be obvious. Something that just because you have a new use for something that's already being used doesn't necessarily make that not a non-obvious use. It has to be something that you can prove is innovative or cutting edge. And that can be, if you're like in a research lab, you have data supporting that, the results that I got are unexpected. They're kind of phenomenal. And if you can prove that, then even if something is kind of obvious, that might be enough to win the argument. So what we're talking about is the whole prosecution process. So like I said, what starts off is an initial filing. Then what happens is an examiner, like I was for 10 years, an examiner will search and search and search. And if it's a tough technology, the examiner can't find anything. Like I said, the government has unlimited resources. Really not unlimited, but they have a lot more resources than your patent attorneys or patent representation. Like me, I'm a patent agent. So basically, they have search specialists they can go to. They can go to an office and say, hey, there's somebody paid on staff that just research all day. They don't write any responses. They don't do anything else but just do research. They might be librarians. They might be PhD research students. Who knows? These people are experts at researching. And they might be technical experts, meaning that for your particular technology, they may have worked in the field for 10, 15 years and be experts. It's just an extra job they have. So I can go, it's like going to the library and saying, I couldn't find this, but here, librarian, can you find this for me? The patent office has libraries. They have a ton of librarians that can help them out. And so these search specialists, they have basically an army of searchers that can look for things that, your patentability and search and assessment necessary didn't find. And plus, there's a time that's passed from when you first did that assessment to when we're actually here. So given that timeline, there may be things that have become public information that weren't public at the time. There could be other new inventions. Somebody else could have released a product that's very similar or an invention that's very similar to your invention. So all these things, have to be taken into account. So that's the first part of the process in terms of the search. After the examiner does the search, they're going to give you an opinion that's going to say what? One of three things. They're going to say, is your idea a new idea? Is it novel? So that's under the statute 35 USC United States Code 102. Then they're going to say, is it non-obvious? Meaning, is it not just two things that are already public I put together? It's obvious to use them together because they're already known. You didn't really do too much inventing. You just kind of put two things together that go together. So is it non-obvious? And that's under the statute 35 USC United States Code 103. And then we have one that I know a lot of you software patent guys know all about this one. Is your patent useful? Does it have utility, or is it just some figment of your imagination? Is it an abstract idea? This would be done under making sure it's compliant with US 35 USC or United States Code 101. So these are a series of what's called rejections. So an examiner will give you rejections based on whether it's a useful 101 rejection, or is it just a abstract idea that can't really be applied. Like one example they always give: if you have a perpetual motion machine that's not actually real in a prototype or functioning, you just have something that is in theory. They said that's incredible utility. You're saying you can turn air into electricity or power. You can turn water into power. Unless you can produce the research and the actual tangible evidence, they'll say that's incredible utility. You did something that's like amazing and impossible. It's like magic. We're not going to give you a patent for that because it's just, while you have described how it might work, there's no proof that this is actually physically possible. So that's an example of a one-on-one rejection for something like that. They're going to check to see whether your language and legal language and the drafting of your application is compliant with the USPTO standards. This is going to be under 35 USC 112. So the United States Code 35th section of the United States Code 112. That's going to be the section that's going to deal with your specification and whether it meets the proper requirements. So this is some terminology. If you hear people talking about 112s, 101, 102, 103, what it really means is your invention useful? 101. Is it compliant to standards? 112. Is it new? Or is it just an exact match to something that's before? Like you have an exact copy of something that already came out, that's 102. Or is it just an obvious, is it non-obvious? Or is it just a obvious putting together two things that already are well known? That's 103. So these are the basic things we're going to talk about in this first, explanation of the examination process. We're going to continue this video in another part to kind of explain a little bit more about what happens after you get that response. So the examiner does a search after you file. They give you what's called an office action. This is an official document from the U.S. Patent Office that tells you their opinion. And it's kind of a practice to give everybody a rejection. It's not the law, but in practice, because this is a legal document, legal filing, so the examiner is supposed to do the best case rejection. In some cases, they're just giving you formality, saying, well, we didn't find any actual prior art or evidence of other patents or information or research papers that actually dealt with this information of your invention, but you're not compliant. So, if you meet these compliances, we'll give you a patent. So sometimes you get that's called a quail action. Basically, action that's just saying, hey, we think this thing is patentable, but you got to fix your compliance here. And that'll be a great case. But very seldom, very rarely, out of the 10 years I was there, I don't think, maybe once or twice out of the hundreds of applications I processed did I actually do what's called a first action allowance, meaning that I actually allowed the application. And most of those were not the first time they came in. They were actually a continuing application of a previous patent that I'd already examined. So maybe they had a restriction. But, we can talk about that. You ask me some questions in the comments. I'll make videos to kind of go into different scenarios. I don't want to kind of bog down in this kind of introductory video. But basically, that's the first step of the examination and prosecution process, is that you submit your invention application, the examiner does a search to see if is it new, is it useful, is it non-obvious. And so they give you a report called an office action, and it may contain rejections or objections to things that you need to correct to continue the process.